There are three things that you can't mess up regarding your child's education and religion if you want to win custody of your child. Are you worried about losing custody of your child because the court doesn't fully understand how much you contribute to their upbringing? You're not alone. Many parents are caught off guard when judges dig into the details of how parents show their love, guidance, and support for their child's education and religious values. Hi, I'm Jim Craveld, and for over 30 years I've been helping parents win custody of their children. Let's start with a quick primer on child custody. The judge will review 11 best interest factors. Those factors are part of Michigan law and can be found in MCL 722.23. Of those 11 best interest factors, I discussed the first factor in another video. Don't ignore that information. Today, I'm here to break down another key factor that judges consider when deciding custody. That's factor B. The capacity and disposition of each parent to provide love, affection, and guidance, and to continue the child's education and religious or moral upbringing. If you don't understand how that factor works, that could hurt your case. Stick with me, and I'll teach you how to avoid mistakes and build a stronger argument for custody. Let's get started. So, what is a judge really looking for when he or she reviews factor B? In factor A, the judge is going to look at the emotional bond that exists between you and your child. In factor B, the judge is going to look at your ability and your willingness to create that love, affection, and guidance, and they're going to look at your involvement in your child's education and religious upbringing. Factor B is looking at your ability to provide guidance, so the judge is going to look at your disciplining style. They're going to look at how you discipline, whether you discipline, the way you raise your child. This isn't just about saying you care, it's proving that you're actively nurturing and guiding your child. So let's unpack this factor with some examples. Judges look for actions, not words. And some key areas that the court will look at is, do you bring your child to bed on time? Do you bring your child to school on time? How do you discipline your children when they misbehave? How is your child performing in school? And how have you been involved when they're doing well or not doing well? Do you help your kid with homework? Do you respond to teachers' requests? Do you fix healthy meals allowing your child to thrive? If you previously attended church services, do you still bring your child to their church activities? Or do you go to another church or no church? These are the types of actions that the judges will look at. And if you're not showing your kind of involvement, it could hurt your case. So let's talk about the 3 steps that you would need to take to create a strong child custody case regarding factor B. First, be involved in school. Most schools have options for you to be involved. You can volunteer for the science fair in the evening. If you can only do it in the after hours, you can sign up for cookies that have to be brought for the field trip. At minimum, strive to attend all the events that you can. Remember, if you share joint legal custody, both of you may and should attend parent-teacher conferences. If it's uncomfortable, schedule separate conferences. Second, document your time with your children. Use a notebook, wall calendar, high-tech Excel spreadsheet, but keep track of your involvement. Take photos of your involvement. If you sign up for an event, take a photo of the sign-up sheet. If you're fixing dinner with your kids, take pictures. Kids love silly selfies. Third, although this is sometimes an area of contention, if you were both attending the same church prior to separation, make sure you keep bringing the kids to services and to their kids' activities, and hopefully at their home church. This is especially true after separation, if it's right after separation. You may not have been excited about continuing the religious habits, but you should at least keep up the same concepts of prayer, church attendance, temple attendance, whatever it is. If you agreed to that prior to separation, the judge is going to consider whether or not you're continuing to support the children in their religious education. Factor B is all about your actions, not just your intentions. Are you consistently showing love and affection? Are you guiding your child through life's challenges? Are you supporting their education and their moral upbringing? By documenting your involvement, gathering evidence, and focusing on your positive impact, you can show the court that you're the best choice for your child's custody. But before we wrap up, one more little critical tip. Having great evidence doesn't mean that it's going to automatically be considered by the judge. You still have to comply with Michigan court rules and the rules of evidence. Make sure that your attorney knows how to present your case effectively. If they haven't taken a case to trial, ask yourself, are they the right person for your case? Thank you for watching, and if you found this information helpful, please like, comment, and subscribe for more insights on Michigan family law. And don't forget to check out all the other videos on the remaining 11 best interest factors. The more factors you win, the stronger your case. Take care, and I'll see you in the next video.